Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moelman from Masrimule, and in today's episode we will unpack what if an employee is dismissed for misconduct that took place 5 years ago. Does the Prescription Act apply? Now the matter I will be discussing is Public Investment Corporation versus More, in which the Labour Court delivered a pivotal judgment clarifying the legal position on the application of the Prescriptions Act to internal disciplinary proceedings. First, let's have a look at the facts of the case. So back in June 2020, the Public Investment Corporation, or PIC, charged Ms. More, who was employed as the Chief Financial Officer, with misconduct. The charges related to the breach of her duties committed 5 years earlier, back in 2015. In the disciplinary hearing, Ms. More raised various objections to the charges, including prescription, waiver, and undue delay in bringing of the charges of misconduct against her. These objections were considered but dismissed by the chairperson of the disciplinary hearing, and on 8 October 2021, Ms. More was dismissed. After her dismissal, she referred an unfair dismissal dispute to the CCMA, and at arbitration she raised the same objections of prescription, waiver, and undue delay, which objections were dismissed in her disciplinary hearing. Now, what is interesting is that this arbitration was presided over by 2 senior commissioners. The commissioners firstly dealt with the special defense of prescription. The commissioners had to determine whether the Prescription Act applies to disciplinary proceedings, specifically whether Ms. More's breach of her duties to the PIC fell within the ambit of a debt in terms of the Prescription Act. Now, the commissioners found that it did, and thereafter found that the debt, i.e. the charging and dismissal, had prescribed. Accordingly, Ms. More was reinstated and awarded back pay. Now, the PIC, the employer, took the matter on review to the Labour Court and raised 7 grounds of review. Notably, it contended that the commissioners committed a material error of law in finding that the Prescription Act applied to disciplinary proceedings, in particular to an employer's right to discipline its employees. Now, the Labour Court overturned the CCMA's decision, holding that the Prescription Act applies strictly to the enforcement of debts in civil litigation and has no bearing on disciplinary hearings. The court emphasized that disciplinary proceedings are not akin to court proceedings and do not involve the enforcement or litigation of a debt. Rather, they are an exercise of the employer's prerogative to ensure accountability for workplace misconduct. Now, I want to quote to you what the court said in this regard. Judge Prinsloo said the following: "Let this be clear. The Prescription Act applies to civil litigation in a court of law. It is about the litigation of claims or debts in civil court proceedings. A disciplinary process is not civil litigation. A disciplinary process is not a court of law, and there is no obligation or no litigation rather of a debt involved in a disciplinary hearing. All this indicates that the Prescription Act is not applicable to disciplinary hearings, and the commissioners committed a material error of law in finding that it applies to disciplinary hearings." So consequently, colleagues, the CCMA, the award was set aside and the matter was remitted to the CCMA for arbitration de novo. Some key takeaways. Firstly, disciplinary action is not time-barred. There is no statutory limitation period under the Prescription Act that prohibits an employer from initiating disciplinary action after a certain period. The Prescription Act is inapplicable to disciplinary hearings. Also, disciplinary proceedings are not civil litigation, and it does not involve the enforcement of a debt. The Act, the Prescription Act, does not apply to the internal accountability mechanisms of a workplace. Also, material error of law by the CCMA, their application of the Prescription Act to disciplinary proceedings was a fundamental legal error warranting the Labour Court's intervention and review. The ruling colleagues affirms the employer's prerogative to discipline employees for historical misconduct, even where a significant period has elapsed since the events in question. Timelines, however, remains best practice, so while not barred by prescription, employers should act timeously to address misconduct to preserve fairness and procedural integrity. So in conclusion, the Labour Court's judgment in this case provides important clarity. The Prescription Act cannot be invoked to avoid accountability in internal disciplinary matters. Disciplinary proceedings are not subject to the same constraints as civil litigation, and the passage of time alone does not exempt employees from being held accountable for misconduct. This decision fortifies the legal foundation supporting an employer's right to discipline employees, irrespective of when the misconduct occurred, provided that procedural fairness is upheld. So colleagues, that brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. If you have any questions or comments, we would love to hear from you. You can find us on social media, or you can email me at vapia@massconsulting.co.za. Until next time, bye-bye.